My name is Jolene Wilson-Glaw, and I'm here today with Bruce Steffler. We are presenting a Thriving Through Divorce and Restructuring of Your Family course, and our intention today is that you will leave here after these hours filled with information about the situation you're going through or have gone through, and hopefully power enough to thrive through this relationship breakup and the restructuring of your family instead of what most people call it, which is surviving divorce. As I said, my name is Jolene Wilson-Glaw. I'm an attorney. I'm licensed to practice in the U.S. Supreme Court, the state of Texas, Pennsylvania, and the U.S. Virgin Islands. I'm currently in retired status. I was lucky enough to be able to retire 4 years ago. Prior to my retirement, I practiced predominantly in Texas for 35 years and am board certified in family law in Texas. I'm also a member of the American and the International Academies of Matrimonial Lawyers. Bruce is an attorney who's been practicing in Texas for how long?
Over 40 years.
Over 40 years. Bruce and I became board certified in family law the same year, 1988. Yes. And in fact, over these years have from time to time practiced law together, either as actual partners or in the same office, and I'm privileged to have Bruce here with me. I appreciate his insight and his handling of families, and particularly his work with children that he's done for many, many years. So with that, I would like to begin talking about some of the financial, psychological, and physical effects of divorce on children and adults. In preparing for this, I looked at some statistics that are kept by the United States government and was shocked to find out that a divorce happens in the United States every 36 seconds. There are 2,400 divorces a day. There are 16,800 divorces a week and 876,000 a year. They are the statistics from 2017. That's almost 50% of the marriages that are performed every year. The average marriage that ends in divorce is 8 years before the divorce is finalized. And by that, I don't mean it takes 8 years to get a divorce. It's that they've been married 8 years before they file for divorce. The 10 top reasons for a divorce, some of them were quite surprising to me. The first is infidelity, which was not particularly surprising. The second is money, and that is disagreements over spending habits, goals, earning differences, or control of money. And interestingly, when a woman's earning exceeds a man's earning, the divorce spikes. Lack of communication is number 3, arguing about small things. And I'm not talking about the bigger money issues or fidelity issues. It's arguing over who does the dishes or who takes care of the kids or who mows the grass. Just, backbiting at one another. That is a huge cause for divorce. I also learned yesterday in a different venue that one of the things a man can do which promotes harmony in the marriage is do the dishes, which I thought was really kind of an interesting piece of information. A woman would rather have her husband do the dishes than do the laundry or put the kids to bed. And maybe it's because it's something that's very visible and ongoing and just creates chaos if the kitchen is a mess. Weight gain is the 5th largest cause for divorce in the United States, which surprised me. And then when I read further about that, the issue becomes the health issues that are often associated with weight gain and leads to lack of intimacy and other things, but they've pinned it primarily on weight gain by one, the other, or both parties. Unrealistic expectations, either financial, sexual, relationship, having children. If people don't talk about these things before they get into a marriage, their expectations, which often exist only in their head, is a large cause of divorce. Lack of intimacy, which of course can follow with arguing or weight gain or disagreements over money or infidelity. Lack of equality, like, a mother who says, I don't want you to have anything to do with the kids, or a father who says, I'm not going to do the dishes, and that leads to an imbalance emotionally and job-wise, work-wise around the house. Not being prepared for the marriage, as so many young people are not when they get married. They have no idea how to budget. They have no idea what it really costs to raise kids, the emotional cost of raising children or living independently from their parents. And I've always said that in the United States, most states require you to have a license to have a dog, but no one requires you to have a license or even any education before you have children. And then, surprisingly, I thought this would be higher, but abuse. And it's abuse, mental, emotional, physical, and abuse of spouses or children. That is actually the 10th cause for divorce. Texas holds the title of being tied in third place with 4.2 divorces for every 1,000 people, and that's men, women, and children in the state. There's 4.2 divorces for every 1,000 people. 40 to 60% of all divorces involve children under the age of 18. Of those children, 43% of the kids in the entire United States are living without their fathers. To me, that is a staggering number. 43% of all children in the United States live without their father. And 40% of those children have not seen their father in more than 12 months. 50% of the children of those being raised in a single parent family have never seen their father's home. And 26% of those children live in a state different from their father. Now, what does that impact, or how does that impact children? Well, there are the obvious impacts on children, but then others that are not so obvious. One is that children who are affected by a divorce very often have dramatically increased incidences of injury. They can be small injuries, they can be very large injuries. Also an increased level of hospitalization of children. An increase in asthma, which I found shocking. I thought asthma was purely a physical, but apparently there's a lot of emotional components to asthma as well. They have an increase in headaches. They have an increase in speech impediments, and 50% more likely to have other just more generic colds, flu, other health issues. Emotionally, they have lower grades. They are less pleasant to be around. They have fewer friends. They are more often bullied. Teenagers are 300% more likely than their peers who have not been through a divorce to need psychological help. They are 2 times as likely to try suicide. They get lower paying jobs in their adulthood. They have less college education. They have unstable relationships, particularly with all of the men in their families. They have a history of vulnerability to drugs and alcohol as teens, which often translates into as adults as well. They have fears about commitment and divorce. They have negative memories of the legal system in general, and a very large number of boys never marry. Fatherlessness after the divorce is, as I said, 40% of the kids after a divorce haven't seen their father in more than 12 months. The financial impact of divorce on children and on the parent who is the caregiver, most typically the mother after a divorce in the United States, but not exclusively, is 1/2 of the families after divorce experience poverty, and that is the definition of American poverty level. 75% of the women on welfare do not apply for welfare until after their divorce. For children, this results in a reduction of family income between 28 and 42%. 60% of all women who are awarded child support do not receive all or at least part of their child support. 1/3 of the women who have been in the family home lose their homes after the divorce because they're unable to pay for it. The other effects on children is that they have a dramatically increased possibility of becoming parents themselves as teenagers. Pregnancy is very high. I met a young woman yesterday, 14 years old, who is a mother. Many years ago, like 40 years ago, I was on the board of the United Way, and we were trying to get sex education into a local school district, and we were not able to do that. There was a lot of public resistance to having sex education in the schools in the 70s, and we were doing it through nutrition education. But one of the things I learned was that that particular year, which was probably 1975, 57% of all of the pregnancies in that particular school district were the result of incest. There were two 14-year-olds who gave birth that year that were in the school district. One of them gave birth to her fourth child as a 14-year-old. They have increased sexual activity and decreased support for college, and that's even for attendance to college, not to even mention financial support for college. Single mothers have increased mental and physical illness, increased addiction, and increased suicide. Obviously, they generally have much less time with their children because if they had not worked previously, they're now having to work. And if they did work previously, they often have to have second and third jobs in order to be able to support the children. 44% of women fall into poverty after a divorce. And now this statistic is admittedly probably 20 years old, but at that time when these statistics were gathered, in the ages of 51 to 61, household income for married people was $132,000 a year. For widowed people, it was $42,275. For never married people, it was $35,000. For divorced people, it was $36,670. And for separated people, the household income was $7,600. I've also read statistics that say that men generally recover their financial situation within 2 years of a divorce, and women often never recover. So, generally speaking, divorce is not healthy for adults or for children. And sometimes we find ourselves in a situation where we can do nothing about that. Circumstances are such that it appears to be the only possibility facing us. And in that particular case, what is recommended is to be armed with as much information and as much support as you can possibly have. And even though I spent 35 years as a divorce lawyer, I really never wanted people to be divorced unless it was really kind of the last option for them. I used to tell my clients, you know, I don't make the decision about whether you're going to be divorced. If you make that decision, then it's my job to shepherd you through the process of a divorce so that you and your children come out at the end as whole and restructured as you can possibly be. And Bruce is going to talk to you now about some of the options that are available that all result in a divorce but make the process much more palatable and user-friendly. So, Bruce?
I've got a couple of comments on what you were talking about.
Okay.
I believe, regardless of the statistics, that the main cause of divorce is lack of communication. I think that all of the other factors that you mentioned are more than likely symptoms of lack of communication. If partners would talk to each other, if they would let them in on their lives, let them into their thinking, then a lot of these other symptoms would go away. Also, with regard to children, generally, children feel that when their parents break up, that it's the children's fault. If I had been a better son or a better daughter, mom and dad would still be together. So it's my fault. What can I do to change this? And that's a heck of a burden to put on a child 7, 8, 10, 15 years old. to have that responsibility or to feel responsible that they are the cause of their parents breaking up. And that's also a lack of communication, communication with the children about what is going on with the parents so that they don't feel responsible, so they can know that they're not responsible for adult situations.
Bruce, before you go on, I'd like to comment on your comments, if
Go
I
ahead.
may. And one of the things that, in line with what Bruce is talking about, that you can do to assist your children in this process is to make sure that you encourage them to be honest, how they're feeling. I remember when I was going through a divorce, watching my daughter as she was driving down the street with her dad for visitation, and she loved her dad. She tried to climb out the car window. She was 2.5 years old. And when her dad stopped the car, and I obviously ran up and we were talking, she said, "I want to stay this weekend with both of you," which was a very honest statement and gave me the opportunity to say, I get that. That's a nice one, but that's not going to happen this weekend. So you need to encourage your children to talk to you about those sorts of things and to help them put their feelings in words. If the children are very angry, they often can't explain the anger, and what they do is act out. But if you encourage the children to really talk to you about what feelings are generating their actions, you will go a long way in helping to alleviate this sense of guilt and terrible pressure that they feel. You need to legitimize their feelings, like saying, I get it, that's what you really want. You want mom and dad to stay together, and it just can't happen right now. And you have to keep yourself healthy as well. There's a lot of victimhood that goes on in a divorce, and people do this unwittingly to make their spouse feel guilty, feel badly, or to get sympathy from their kids because they don't have a spouse, they don't have another adult around, so they look to their children, they parentify their children, they expect their children to take care of them. So you need to keep yourself healthy, and that's physically, emotionally, mentally, spiritually, socially. Have friends, go out, do things together, make plans with friends and with your children that may honor traditions like at Christmas time, but also create your own traditions and moving forward. Keep details of the divorce private. Sometimes you need to tell kids that you're going to the court, or, if a child says, I want to talk to the judge, you tell them that divorce is a grown-up problem. It's not anything that they need to worry about, that mommy and daddy are working it out, and if there's some things they can't work out, the judge will help them work it out. But the children should not be responsible. You shouldn't tell them, we're going to court today so that I can see you, or we're going to court today so that the judge can tell your dad or your mom how much support they have to pay, or we're going to court today so that you can play baseball this summer. That is not anything kids need to know or to hear about. And if you need to get some assistance, get some help, whether it's with a pastor or a psychologist or a family therapist, and get help for your kids if that's what's needed too. So thank you, Bruce, and I apologize for interrupting you.
Okay. Well, I'm going to interrupt you. Adults do what adults are supposed to do. When you're going through a divorce, one of the best things you can do is go to a counselor, because you've never been through this, probably have not been through this process before. You have not been through the emotions involved. So the adult thing to do is go to a counselor, be able to talk. Kids need the same thing. If your children won't talk to you, then take them to somebody that can assist in talking. So you and your children, or you and your child, can go to the same therapist and can develop communication skills. Children need to, when you say don't be involved, they don't need to be involved in the sticky details of the divorce, but they do need to be kept involved as far as what's going on. We can't afford to go on vacation this year, but instead of going to Disney World, we're going to go to Chapel Hill, or we're going to go to the Hill Country. We're going to do something that doesn't cost as much money, but don't make the children feel guilty about spending money. We have plenty of money to buy you clothes, food, so forth like that. It's just that some of the frills are, not thrills, frills are not going to be there. So let me talk about the process of divorce. Generally, a divorce is like any other lawsuit. There is a plaintiff and a defendant, or in the case of a divorce, it's a petitioner and a respondent. And those are just names. Petitioner is the one that filed first, the respondent is the one that responded to the divorce. But it's just like a lawsuit over a car accident. It's adversarial. The plaintiff or the petitioner is against the defendant or the respondent. They are at loggerheads and can't agree on things, so they're going to have a judge or a jury make those decisions. Divorce is supposed to be as non-adversarial as it can be in a court situation. So court situations are adversarial in that you have one side against the other. One side is asking for information from the other side. One side is asking a court to make orders with regard to use of property, visitation with the children, child support, and so forth. It's an adversarial process. There are other processes that aren't as adversarial, and I'll speak to the first one being mediation. Once you file a lawsuit, all of the courts, at least here in Harris County where I practice, require that you go to mediation before you can even have a hearing to decide temporary custody of the children, temporary visitation, temporary child support, and so forth. You have to go to mediation first. The reason being is that a lot of cases settle in mediation. But if that doesn't happen, if you go to mediation, get your temporary orders, then you're going to operate under those orders until you can have a trial. That could be a long process, 6, 8, 9 months, over a year. So the best situation for the family members, children, mom, dad, the best situation is to come to an agreement that each of you can live with. Okay. Mediation process. In mediation, generally, especially in a family law matter, mom and her lawyer will be in one room, dad and his lawyer will be in another room, and there will be a mediator who is a disinterested third party. Disinterested means that they don't have an interest in the litigation itself, but it doesn't mean that they're not interested in your divorce or in your situation. The mediator then goes from room to room asking questions, gathering information, and attempting to find a middle ground that the parents can live with and that the children can live with also. It is not as effective as some of the other ways to gain a divorce that I'm going to talk about, except that it's better than going to trial. It's better than going to a hearing. And what I always tell my clients is the judge is a politician, pure and simple. Judges are elected, at least in Texas. Judges are elected. And this person, this judge, has a limited amount of time to hear your story and to hear all the information that he or she needs in order to make an informed decision in your case. Well, that politician has a limited amount of time to hear your case. If you go to a divorce courts, family courts here in Harris County on any morning, you're going to hear docket call. And there's going to be 5 to 10 other cases that are going to be heard that day. So the judge doesn't have time to hear your entire story, to get the flavor of your divorce that you have. So you're time limited. You have to hit the high points, and then this judge is going to make a decision that's going to have a profound effect on your children, on you, on your financial situation. So the worst thing you can do is have a judge make a decision in your case about where your children are going to live, how they're going to see the other parent, how often they're going to see the other parent, and what's going to happen with your paycheck. So mediation is the best alternative to having a judge make a decision. But mediation is still part of the adversarial process in that you're in one room, or mom's in one room, dad's in another room. They are adversaries. They are fighting with one another. The mediator just tries to channel them into an agreement that will work for them. Go ahead.
Bruce, I would like you to address the fact that mediation is binding once there's a settlement
yeah.
agreement. However, a mediation cannot be, an agreement cannot be forced by the mediator.
No. Mediator, number one, the mediator is a disinterested third party, and the law provides that the mediator cannot be called to testify in any type of court proceeding, in a trial or a temporary hearing. So anything that you say to the mediator is going to remain confidential between you and the mediator. Although if you make a statement to the mediator and then give them permission, they can give that information to the other side so that everybody has the same information from which to operate. But Jolene's correct. Once you enter into a mediated settlement agreement, then that agreement is binding. Both parties are entitled to go to the judge and have a decree or an order entered pursuant to the terms of the mediated settlement agreement. So you can't go home that night and after mediation and after you've signed the agreement, excuse me, and say, King's X, I want to do it over again. You can't do that, except in very limited circumstances dealing with fraud and so forth. So yes, once you enter into a mediated settlement agreement, that is going to be your agreement. It's going to be reduced to an order, and that's what you're bound by, either pending the divorce in the case of temporary orders or a final after you have a mediation with regard to final settlement. Excuse me. There is another process that is fairly new within the past 15 to 20 years, and the concept is called collaborative law. And what collaborative law does essentially is says this is the situation we're in today. We're not going to look back and place blame or anything like that. We're going to work from this is today, this is what we have, these are our children, and these are our wishes and desires. And it's not couples that are separated into separate rooms as in mediation. Everybody sits around a table. The mom, dad, their lawyers, and any professionals that they have, such as financial planning professionals, CPAs, and so forth like that. And you exchange information. You agree as to who's going to give what information. Well, dad's going to get from his employer, he's going to get an accounting of what's in the retirement plan, or what medical insurance is available for the family and especially the children after the divorce. So it's more informal. There's no court proceeding. As a matter of fact, you file for divorce, and if you decide you're going to do collaborative law, then the court gets a notice that you're doing the collaborative process, and all court proceedings stop at that moment. There cannot be any more court proceedings until the parties either tell the judge that they've settled and this is their settlement, or that they're unable to settle. And at that point, then it goes back to being a adversarial court case with one big 500-pound elephant sitting in the room, and that is, if you do collaborative law, you notify the court that you're doing collaborative law, and you cannot reach an agreement through the collaborative process, and you're going to go into the regular adversarial process, then all of the professionals, the lawyers, the financial planners, and so forth, they have to get out of the case because they've been at a table and received information that they normally would not have received in an adversarial process. So if you go into the collaborative process, most of them settle. So this shouldn't be a big objection to doing collaborative. But if you don't settle and you go to the adversarial process, you have to hire a new lawyer. You have to hire new psychologists. You have to hire new financial planners. So that's the big difference. But it's non-adversarial. People don't go away from each other hating each other. When I talked about how you have to hit the high points in an adversarial proceeding so that the judge has enough time to hear you, what normally happens is you pick an incident from here, an incident from here, and an incident from here. You have testimony on those, and you bring out the bad stuff. And after you brought out enough bad stuff, the other side's going to be mad, and they're going to do the same thing. So the adversarial process is the least, it's the most objectionable of the procedures. So collaborative law is the next best thing to having an adversarial proceeding. The next best thing is what's called arbitration. And that's where you have an adversarial process, but you don't use the judge. What you do is, in effect, you hire a private judge, an arbitrator, and you present your evidence to that arbitrator, and that arbitrator makes a decision just like a judge would. The difference being is that it's less formal, less adversarial, and more,
It's a kinder, gentler.
kinder, gentler, because you've got all the time you want. You're not limited to 2 hours with the judge. You've got all day if you want it to bring your story out, but it still has to be pursuant to the rules of evidence and the rules of civil procedure. But it is less formal, and it is being less adversarial. You don't say as many hateful things about one another. But it's just as binding as an adversarial process. So normally, adversarial process is very expensive. There's a lot of emotion involved. You're bringing out bad things about the other side. Next, and in the adversarial process, you can use the mediation process to still try to reach an agreement, either on a temporary basis or on a permanent basis. The next best thing is the collaborative law. I mean, the best thing would be collaborative law, because you're working together. It's not adversarial, and you don't have to bring out all the bad things that happened in the past, because you're starting from today and you're trying to divide your assets, not divide your kids, but make a situation for both parents to be able to see the kids, but more importantly for the kids to be able to see both parents. Now, mediation, arbitration, and collaborative are all end up in the same place, and that is with a divorce decree that is the document that the two of you or the family lives by after the divorce is over.
A couple of extra points, Bruce. First of all, when you enter into a collaborative law process, you are required to sign an agreement that acknowledges that you are working together and that you understand if there is a breakdown that you are basically starting back at ground zero again in terms of financial expenditures. During the collaborative process, you hire one financial expert, you hire one mental health expert, you hire one financial planner. And if you then have a breakdown and have to go back to the adversarial position, you are in a position of not being able to use that financial planner. Mom has to go get her own financial planner, Dad has to get his own financial planner. So you've made the cost exponential, because you now have 3 experts on finances, and you've now paid 4 lawyers, because you each have to have a new lawyer. And as Bruce said, you say all of the hateful things that never benefit anybody. They don't benefit your children, they don't benefit you, they don't benefit your spouse. You cannot unring a bell. It's there forever, and it leads to so much future resentment. And I think that it's very important to understand that in mediation, the mediator cannot force an agreement. He or she cannot say, I've listened to both sides and this is the visitation schedule you should have. They cannot do that. The parties must come up with their own agreement. And who knows your children and your family and your financial situation better than you do? No one. Trust me. And then arbitration is exactly the same as an adversarial proceeding in a court, except you have to pay the judge. You don't pay. And some people go that route because they may have a very complicated financial situation, and they feel more comfortable having a judge that they know maybe has background as a CPA or may have a background as a mental health professional, and they can better understand the testimony or something like that. Or there could be a year wait in the court, and so this is not a very flattering term, but they hire a judge basically. But that decision is unlike a mediator. They can force the decision. They make a ruling just like a judge does. And then in the collaborative process, it is exactly that. It's collaborative, cooperative, and you end up with a decision that is best for everybody. And if you walk out of a mediation or a collaboration and you feel like you've won, you haven't won, you've lost, because no one ends up 100% satisfied with anything in the divorce process, because your life, there's no way to support two households on what it used to take to support one. It's just not possible. You come up with the best of all worlds, except a judge, they will come up with the most expedient resolution. And there's just not room. For instance, if you have someone that works shift work, a standard possession order that's listed in the family code will probably never work for your family. So it's an opportunity to really massage the situation and make a decision or make an order going forward that's best for your children.
The goal from a divorce should be that the family can continue, but just in an altered way. It shouldn't be that you continue with mom against dad, the children against mom, or the children against dad. The goal should be that you still have a family, although it's a restructured family, a family that works. And I go back to my original premise that communication, I think, it should be the main goal of any marriage. There are churches that you cannot get married in the church unless you take a pre-marriage course through the church, so that you can hear these factors. You can hear about, well, this is what happens if you go to divorce. Here's what your rights and duties are with regard to your children. There are 10 family district courts in Harris County. Each of those family district courts has 3,000 cases pending at any one time. There is no way that a judge can hear 3,000 cases even in the time of a year. So if you're in the adversarial procedure, it could take you a year. It could take you 2 years to get divorced, depending on the court you're in and the complexity of your situation. So the best thing to do is to settle. Collaborative is the best. Arbitration is just as good because it's quicker, it's cheaper, and it's less formal. And you usually walk out of an arbitration feeling a lot better than you do if it's an adversarial procedure. If one party feels like they've won, that just continues this us against them.
Exactly.
So.
And in terms of communication, there are, as Bruce has mentioned before, many, many resources available to families and individuals, whether it is through church counseling or some informal counseling group. There's lots of self-help books. There are lots of other courses out there available. And in terms of your children, communication is absolutely number one. And it's communication both with your children and with the other parent. And I have a form that I've put together. Actually, it's just some suggestions about how to reach agreements. A divorce decree will never talk about how you make decisions and agreements with your ex-spouse about whether Johnny's going to play baseball this summer. And trust me, if you have a parent who is exercising their visitation, summer baseball will absolutely interfere with their times of possession. And so they have to be on board. They have to be in agreement. And if you try to get an agreement by strong-arming someone, that will never work. And if you continually leave out important parts of the information, like, I'm going to sign Johnny up for baseball and it costs $40, but you forget to tell them that it includes practice every day of the week, and if they miss 2 practices, they don't get to play baseball. And maybe the parent who is having the visitation time or other parenting time is planning 2 weeks out of town. Well, you need to find that information out before you have angry children, angry parents, angry teammates because, they were expecting Johnny to show up and play shortstop. So I have put together some recommended communication forms. Like, if you're trying to get an agreement with the other parent about an issue that's not addressed in the decree, you might want to use the following communication guide. Have direct communication with the other parent, preferably via email, so that there is no misunderstanding. Do not use the child as a messenger, and do not involve the children in the negotiations or the conversation. Now, obviously, some of that changes as the kids get to be 14 or 15 years old and they want to have some input. You know, they should be involved, but they should not be the decision makers. They are children, and they don't like to have that kind of power. There's so many studies that have come out and said, you give children too much power and they become terrorists. They really do, because they think, well, it worked before, so if I kick and scream loud enough and long enough, something will change. Be specific about the issue that you want to address, such as sporting enrollment or a birthday party or a physical checkup or a family event or a school activity. If there is a deadline to making the decision, state what the deadline is, and don't call them today for a decision that has to be made before 8 o'clock tonight. State when you would like the response, be specific about your request, and include all the details. And if an agreement is reached, at least in the beginning, it probably should be put into writing so that there's no he said, she said, that sort of thing. For example, you would like to have your child enrolled in soccer. You might send the following email. I would like to enroll Chris in the neighborhood soccer league. The practices are on Tuesdays and Thursdays from 3 until 5, and games will be every Saturday between 9 and noon. All practices and games are at the community park. The season lasts for 12 weeks. The cost of participation is $60. Soccer shoes will be extra. Because I know that some of the practices and games may be during your parenting time, I would like to have your agreement and commitment that you will support Chris in participation. Are you willing to commit to that? If so, will you commit to driving and picking up Chris from practices and games which may occur during your parenting time? Are you willing to share the cost of the season and the soccer shoes? The coach needs to know if Chris will participate by a week from this coming Monday. Can you let me know your decision no later than the Friday before? Thanks so much. And if you want to talk about this or have any questions, let me know. So, you know, you've addressed all of the things that the other parent needs to know, presumably, in order to get an agreement. And, you know, I think that if your child has their heart set on this, you might not want to discuss it with the child before you discuss it with the other parent. Because, you know, like I said, maybe they have plans to go to a family reunion, and maybe there's a way that Chris could miss a practice or a game to be allowed to go. But you have to know that from the coach before you get the kid's heart set on it. There was a case a number of years ago where the kid was selected for the National All-Stars team, and one parent wouldn't let the kid participate. You know, and in that particular case, it was for no good reason, except they were just angry. And then there are situations, of course, where parents don't have to involve the other parent, and it's a good idea to keep the other parent always involved. Remember the statistic: how many children never see their father or haven't seen their father in 12 months? I mean, that's a tragic situation to have a child. Remember, you picked this person out of a crowd of people to be the parent of your children, and it's not your children's fault. So in a situation, for instance, that one parent has the right to make exclusive educational decisions, you don't have to involve the other parent. However, it's recommended. So you might send an email like this: I think it would benefit Chris to have an evaluation by an educational consultant. Dr. Smith has been recommended to me as an educational diagnostician, and I would like to make an appointment. I would like to have your participation in this, and if you have any other recommendations, please let me know. I plan on scheduling an appointment before the end of the month, and will go ahead and make the appointment if I have not heard from you before the 20th. So it gives them an opportunity, whereas if you just say, I'd like to have your input on this, and there's no by when deadline, when you're ready to make a decision and have made the appointment, then the other parent can say, well, you never gave me a chance to respond, but you never told them when you needed a response. So it's all about communication. Be very clear, be very specific, what it is that you want, what it is that you expect, and what the implications will be for the other parent, what the cost will be, what the time commitment will be, that sort of thing. And I think that we overlook the fact that our children look at us and believe themselves to be 50% of their mom and 50% of their dad. And when one parent is either excluded or excludes themselves, we don't think about what it does to the children's self-image. And I read a quote one time that I thought was better than just about anything I've ever read about divorced or even intact families where they quarrel a lot, and that is, every arrow you aim at your spouse lands firmly in the heart of your child. And, it's something that should never be forgotten. Even in intact families, people make commentary. Your dad won't let you play baseball because XYZ. Those kinds of things are never beneficial. So communication, communication, communication. As Bruce said previously, there are requirements in Harris County, at least, and in Fort Bend County for mediations. There are also requirements not only in this state, but in 17 of the states in the United States that make parenting courses mandatory before a divorce. 17 of the states, you may not be divorced in any case that involves children, contested or not contested, if you do not take a parenting course. And in Harris County, they're required before divorces. In Fort Bend County, they can be provided or required. The statute in Texas says that if the courts require a parenting course, it must be at least 4 hours minimum and must include certain factors. We have prepared a course called Co-Parenting into the Future, which really is more a communications course than it is anything else. It allows parents to look at what part of their own behavior contributed to the demise of the marriage. And if parents are unwilling to acknowledge that they had any part in the demise of the marriage, I think the future of the communications between the parents are highly compromised, because it is never one person's fault. As I said, you pick them out of a crowd. You must have thought there was something really wonderful about that person, that not only did you marry them, you chose to have children with them. And one thing I used to do sometimes when I had a very contentious case was that I asked my client to list 5 good things about their spouse before we went into a hearing. And, they could sometimes come up with them, sometimes not. And one client said to me, "There's nothing good to say about my spouse." And I said, "Well, can I start?" And she said, "Sure." And I said, "He's got the best blue eyes I think I've ever seen." So it doesn't have to be anything more than those kinds of things, but it starts you thinking on a path. Okay, they're not all bad, or, she makes the greatest pasta in the world. That gets you on a different level of thinking. And those are the kinds of things that are appreciated by your children. To say, your mom makes the best brownies I've ever had. You're going to look forward to those this weekend. Or your dad is the best baseball coach I could imagine that you could have. Or, talk to your dad about that science project. He's really good at those things. So whether you've had a good marriage, a bad marriage, an indifferent marriage, an intact marriage, or a restructured family, those are things that I think every kid needs to hear from their parent.
And it's difficult to do when you're in an adversarial
Of
position.
course.
And when you're in an adversarial position, it carries over to the post-divorce. It carries over to how you're going to operate with each other. Jolene was talking about communication. Well, there are some moms and dads that just are unable to communicate with each other effectively after the divorce. There's an out for that, and it's called the World Wide Web. There are programs out there, and the one that I use mostly is called Our Family Wizard. It is an internet-based platform that has several modules to it. One module is a calendar. So both parents, and it costs $99 a year each, both parents use the same calendar with regard to their children. So if mom is taking Johnny to the doctor next Wednesday at 2 o'clock, she can put that information on the calendar that dad has access to. The children are encouraged to participate in our Family Wizard too. So if they've got a birthday party on Saturday, they can put that on the calendar so that both parents are aware of what's going on with the child. They can also put on there, you can go to this web page to get all of the information about Johnny's baseball, who the coach is, when the practices are, when the games are. So the calendar module in and of itself is, I think, a great thing so that everybody knows the children's schedule, so that they can plan around the children's schedule. And that's the way it should be with any child. Their schedules should be taken into consideration by the parents, and you should plan around the children's schedule, not the children planning around the adult schedule. Another module is like, what's it called, texting, where you have or email. So you have a module that you can use to talk to one another as if you were texting. It does several things. One is your discussion is engraved in stone. It's there. This is what you said. So there's no discussion later. Well, you said this, but you say you said this, but this is what I heard. Well, if it's in writing, you've got it, and you can go back and forth, and you can make agreements that everybody knows what the agreement consists of. There's also a financial section to it. So if dad is supposed to pay for half of the child's uninsured medical expenses, you can post that bill to that section, the financial section of our Family Wizard, and everybody knows when the bill was given to the other parent, when they had the right to access to it. And there's another feature that I really like, and that is every time you log into our Family Wizard, it makes a prompt in a particular section. So you can go to this section and see when every time dad got onto our Family Wizard, the date and the time, when mom got on, and so forth like that. So you can tell if they're using it, or they say, well, you didn't tell me about this. Well, you haven't logged on to our Family Wizard in a month, so if you had done what you're supposed to do, it's right there. So nobody has these excuses of not informing the other parent. It's a good way to provide for communication between the parents, and also between the parents and the children and the parents. Jolene was talking about requiring parenting courses. The Harris County local rule said you can't take testimony in a final trial unless you've had the parenting course. So in other words, you do the parenting course, or you're not going to be able to testify at trial. There's one court in Fort Bend County that requires that you take the parenting course within 30 to 60 days after you file your lawsuit. So if you file the lawsuit, you have, I think it's 60 days, to take the parenting course. And the other side, the responding side, I think they have 30 to 60 days after they file their response. So the parenting courses are so good for the families that they require it at the start of the suit. So when you're starting to get into the adversarial position, then you've taken the parenting classes and you've learned some skills that you can use during the adversarial process that keeps the children out of it. And it can be simple things. You have temporary child support while the divorce is pending. Well, sometimes dads will pick up the children for his parenting time, and when he takes the children back to mom, he says, "Here, give this check to your mom. It's the child support." That's making the child, number one, responsible for getting that check to the right person, makes them responsible for, in effect, dad paying mom. It puts a lot of adult duties on a child. And the child already feels, if I'd been a better kid, then my mom and dad would still be together. So you learn simple, straightforward things that you normally wouldn't think were bad for your children or weren't good parenting skills to use during the divorce.
There are a number of books that I think are really wonderful for children. One is called Dinosaurs Divorce, and it's for young children, and because the divorcing parties are dinosaurs, It sort of removes that level of if I were a better kid from the children. And it talks about things like, what happens when I get to dad's house and my favorite toy is at mom's house? Or what if my dad has a girlfriend at the house or my mom has a boyfriend at the house and I don't like them? It talks about those things that kids have in their heads. There's another book called Divorce is a Grown-Up Problem. It's a book that I found in 1976, and it's still in print because I found it the other day, although you have to order it. And the child is very androgynous. The child's name is Chris, which could be a boy's name or a girl's name. The child has longish hair, so the child could be a boy or a girl. And it's also black and white, so it's a coloring book. And it's very interesting to watch as children read these books, and if they decide they want to color, if they use a lot of black, you might want to think they have some anger issues or something. So it's a very good book. There's also another book called The 5 Languages of Love for Children, and it was written by a man named Gary Chapman. And they have the book for adults, which is a great book. They have the book for children. They have a book for teenagers, which is basically how to speak to and show love for your children based on how they receive love. There are 5 basic ways to receive love and give love according to this person. He's certainly not the guru, but I have found his information very helpful. And one is that some people respond more to physical touch. Some respond more to quality time. Some respond to gifts. Some respond to acts of service. And the last one is, I'm sorry, I have forgotten at this moment. Let's see. Quality time. Oh, words of affirmation. You've done a great job. Or would you like me to help you clean up your room? And children receive and understand love in different ways, just like adults do. And teenagers are yet another whole level of complexity. And the book for teenagers is very interesting about how to communicate with teenagers and how to read their communication back to you.
No, there's no way to communicate with teenagers. It's impossible. Can't be done.
Well, they think it can be done, so maybe it's helpful for us to learn how to read their communication.
Yeah.
Co-parenting into the future, creating a working relationship between parents that provides for a successful future for your children. Why should parents take this particular course?
One of the reasons why I would encourage people to take this course rather than some of the others that are out there is because this course really gets to the cause. It gets to the root cause about not so much a list of things to do with your children or a list of behaviors to avoid. It really gets to what happened, how are you going to deal with it, and how are you going to move on. And it teaches people how to get in touch with their own stuff that went on and to own it and to let go of it and move on. And, you know, in my line of work, we always talk about forgiveness. Forgiveness is a gift you give yourself. You don't do it for the other person. And I think people miss that a lot. Well, forgiveness can be a really positive byproduct of getting in touch with your own stuff and getting to the root cause of it.
Why is it best to take this course early in the divorce process?
It's always best to take the course early in the divorce process for several reasons. One being that most parents have not been through divorce before, and probably their children haven't either. So nobody knows how to act when they're going through a divorce. What the parenting course does is give the parents tools that they can use to address the issues that come up between the parents, as well as between the parents and the child and the parents. So with these tools, it makes it easier for the children, as well as the parent, to recognize issues when they arise and know how to best address those issues. It makes the process of the divorce easier, but it also gives the parents the information they need to be able to react to their children's reactions.
The consequences for not getting this right, in other words, are extreme, in my opinion, on children.
These are possible outcomes that are available for you in taking this workshop. And in developing the workshop, this is what we're committed that people get out of this workshop. So the first one is that you will be enabled to be effective in dealing with the divorce process, its aftermath, and have more freedom to get on with your life and more peace of mind. You'll be more enabled to assist your children during and after the divorce. You will be more at ease in dealing with your spouse and their attorney in the divorce process. You will be more at ease in dealing with friends and colleagues and your family and your spouse's family during and after the divorce. You will develop creative and effective ways to resolve difficult issues, such as holidays, discipline, education, and social activities, and will learn to create agreements for interacting with each other. You will learn ways to be able to come out of the divorce with a relationship with your spouse that is supportive and effortless, including not having what we would call poisonous conversations with the children and other people about your spouse, because this can often create damage to the children's relationship with both parents. You will develop an understanding of what happened so that there's an opportunity for past events from the marriage to have less impact on your future and your children's future. You will look at ways to get beyond anger and resentment. You will learn how to forgive yourself and your spouse for the breakdowns that led to the divorce. And most importantly, you will learn how to create a successful future for your children that's not based on the past and is not business as usual.
Okay, what you all have just seen is a 5-minute trailer for the co-parenting course known as Co-Parenting into the Future. And it's a course that has been put together over, believe it or not, a period of 17 years by two parents formerly married to one another and absolutely 100% dedicated to their children. No matter how much they didn't want to be married to one another, they were dedicated to the well-being and the support of their children, both of whom are adults now, and they are wonderful examples of what good communication between parents can do. The thing that I think is important to know about this course is that it is not just for divorcing parents. It can be for divorced parents. It can be for parents who are going through a difficult time. It can be for people without children, is what I've been told by some people who've reviewed the course and have said it was so helpful in dealing with just communication issues with her spouse. And they were not in the process of a divorce. So it's something that I encourage you all to look at and consider and see if it fits into your life. I think it is something, a great gift you can give to yourself and to everyone else involved in your life, because it certainly is not limited to time of divorce, learning to communicate. One of the things that is important to understand, and I think is often overlooked by people in our society, is a duty to report any kind of abuse. Lots of times, teachers discover abuse with children, doctors discover abuse, not just parents discover abuse. And reporting of abuse or suspected abuse is mandatory in the state of Texas, and I'm sure in most, if not all, other states. And the requirements of the report are fairly specific. You must list the name of the child. You must list the name and address of the person you believe who is physically, sexually, or emotionally abusing the child, and it must be filed with the police station. So I've, in my career, heard teachers say, well, you know, I thought that maybe Susie was having problems at home. The thinking is not sufficient. You have a legal duty to report. So even a suspected abuse needs to be reported. The caveat to that, however, is that false reports are very highly frowned upon. And they are subject to a fine of up to $500 if it is found to be a false report. And if you have a concern that a child is being abused, my recommendation would be to take the child to a counselor or to a teacher or to another professional and verify whether your suspicions could possibly be true. The requirement, the legal requirement for a professional is that it must be made within 48 hours of any suspicion that you have. And for non-professionals, it is listed as immediate. I'm not sure what the difference is between immediate or 48 hours, except maybe they give the professionals, like a teacher, a weekend or something like that, because it has to be done within 48 hours. But I think that you need to be very careful. And in custody cases of all kinds, you hear it thrown around that, you know, stepdad is disciplining the child, or stepmom is talking ugly to the kid, or something like that. So you need to be very careful about what you call abuse, but you also need to be very careful to listen to the children and to find out whether the concerns that you have are legitimate. There also is, in most states, a recommended visitation schedule. And this is an opportunity, doing either the collaborative process, mediation process, or arbitration process, as opposed to an adversarial court hearing, where you have the opportunity to create something that works for your family. And they can be very, very creative. I've known of cases where the parents moved in and out of the house, and the kids stayed in the house. And the parents had the economy that what they did was they jointly rented a 2-bedroom apartment. They jointly decorated the 2-bedroom apartment, and they had a lock on each bedroom door, so that when mom was in the apartment, dad's bedroom was locked. When dad was in the apartment, mom's bedroom was locked, and the kids stayed in the house that they had lived in for 10 or 15 years. So, and Bruce, I want you to comment on the adult-centric or child-centric case.
And we had discussions during the break. I believe, and a lot of professionals, mental health professionals, agree that any plan that you come up with for parenting time should be child-centric, so that you look at the child's wishes, desires, and needs, and those should be paramount in determining a parenting plan, rather than having it being adult-centric. And I read something disturbing yesterday, I think it was, or the day before, about there's an organization out there that is trying to get the law changed in one state to provide that parents have equal time with their children. And what got me about it is, and I think it was a dad's group, was that they said, well, if you've got equal time, then you're not going to be paying child support. So dads are getting together and say, well, you know, it shouldn't be me having every other weekend and visiting with the children. It should be that we have equal time with the children, and I don't have to pay child support. Well, that's not child-centric. Child-centric is the child has a seamless life regardless of who has parenting time with that child at that time. So when you say, well, we're going to come up with a plan where each of us have equal time, well, think about the kids. The kids need to wake up in the morning and not have to worry that they left their jacket at mom's house. They shouldn't wake up in the morning and discover that their homework is at the other parent's house. They shouldn't go to bed at night without their pajamas because they're at the other parent's house. Everything should be child-centric to fit into, and the parents make that fit into their lives. If you have the child for a weekend and Johnny has a baseball game, that mom signed him up for, take him to the baseball game. That's your job. A lot of parents say, well, Dad doesn't know what to do with the kids on his weekends. Well, Dad should do what Dad does normally on weekends. If he normally goes to the hardware store, take the kids with you. Fold the kids into your life. Don't try to make them make their lives fold into yours. You should fold their lives into yours. That's one thing about being kid-centric. Kids shouldn't have to worry about where they're spending the night that night or what they're doing this particular weekend. It should be that life goes on normal for them, and the parents are going to get them to their baseball games, get them to the birthday parties and so forth. But that's all deals with the same principle: communication between the parents, so that the children have a seamless life.
Exactly. Yes, that reminds me again of a study that was done a long time ago about children after divorce, and that if they go too long, they have a distorted sense of time. And every other weekend really doesn't work for a lot of kids because it's too long to go without seeing their other parent. Now, some states have what they call a 2-2-3, which is children are with parents one parent Monday and Tuesday, the other parent Wednesday and Thursday, and then they switch weekends. So one weekend it's Wednesday, Thursday, Friday, Saturday, Sunday with one parent. And the next, like 2 weekends later, it is Thursday, Friday, or Friday, Saturday, Sunday, Monday, Tuesday. So there's a 5-day block every other week with the same parent. There's a 5-day block each week with one of the parents, and then they do days. But, you know, there are lots of ideas. There are books out there. One is called Miles for Mom, I think is what it's called, and the other one is called Dads at a Distance, which are things you can do to keep up communication with your children. And now with FaceTime, you can get on a call with your kids, you know, every day or every other day, and you can read them a good night story, or you can even play with them on FaceTime, read them books. There are so many things that you can do to keep yourself involved with your children, and that should be promoted by both parents so that they know that their dad and their mom love them and are in communication with them, and that, you know, their life is restructured. It's not from a broken home. They are from a restructured home.
Yeah. And I really dislike the 3-2-2-3 plans, or the plans that try to provide equal time for parents, because it shouldn't be about equal time for the parents.
Right.
It should be about what is best for the kids. And if I were a child and custody or possession parenting time changed on Wednesday, I sure as heck wouldn't want to go to school with a suitcase with my clothes that I'm going to take to Dad's house for the next 2 or 3 days. I shouldn't be the child that wakes up on Friday morning and says, where am I going to be this weekend? I just changed on Wednesday and I changed on Sunday. Where am I going to be this weekend?
Thank you.
Mm-hmm.
Child support is figured in different states differently, and Oklahoma, for instance, is a state where the state, in its infinite wisdom, has determined what it costs to raise children, that one child costs, I don't know, $1,500 a month or whatever, and they take the net resources of the father and the net resources of the mother, and they do an application of child support based on the ratio of those incomes, those net resources. So it could be that Dad's net resources are 25% higher than Mom's, and they presume in Oklahoma and a lot of other states, and Texas too, but to a different, in a different way, that each parent has the duty and obligation to support their children, and so they take the gross amount that they've determined it takes to support the child, and they apply the same ratio to that number as the parents' incomes are related to one another. And mom's duty to support might be $500 a month, and dad's duty to support might be $1,000 a month. And so the child support, if dad is going to be paying, is $1,000 a month, because it's presumed that mom's going to be putting $500 towards that. And there are different formulas like that in different states. The other thing that I think it's important to keep in mind in terms of communication and coming up with an agreement for your children long term is that if you go strictly by the law, as Bruce mentioned in Texas, the presumption of minimum time with your children is going to result, depending on the year, anywhere between 39 and 45% of the time. And when I say depending on the year, sometimes Christmas vacation might be longer, or they might have 10 days for spring break or whatever. So the question becomes, what would be the benefit in fighting? Why would you use your family's resources and the emotional cost of a fight to get 1% more in terms of days? Or try to get more child support that is going to be probably impossible in the end. Now, there are provisions for child support above the guidelines based on very special circumstances. For instance, if you have a family that has a very good standard of living and good income, and your children have always gone to private school, there may be an argument that child support should be above the guidelines in order to pay for that private school. The alternative is, in mediation or collaboration, maybe an asset can be set aside to pay for the kids' private school, or the payment. Lots of times people bristle at the idea of writing a check to the other parent, so the child support can be paid to the other parent, but the tuition can be paid directly to the school. And again, this keeps the case child-centric and makes the children not suffer for the sins of the parents, so to speak. They have decided that they're going to go their separate ways, but this is still the children's family, and that's a way to have what's beneficial for the children without a fight and without feeling like you've lost something.
And like Jolene said, these are agreements that the parents reach between themselves. Mm-hmm. I can almost guarantee you that a judge looking at this same situation is not going to go out on a limb and do something that would more fit your family situation than something that the judge decided. So it goes back to communication, it goes back to cooperating in the divorce so that the best interest of the children is paramount to both parents. And we saved from near the last to talk about property division. As you've noticed, most of this course has been about restructuring your family. Part of divorce is still property division. And there are some special needs that can be taken care of in property divisions. But generally the law is that the court, if the court makes a decision on how to divide the property, they do it with the eye towards a fair and equitable division of the property. In Texas is a community property state, so I'll use that as an example.
There are 9 states in the United States that are community property.
Yep. And what that amounts to is that each spouse owns an undivided interest, 50% interest in everything that the two of the spouses have accumulated during the marriage. But in the community property states, you have that community interest. In separate property states, you don't have the community interest. But the division of property usually depends on what is fair and equitable to the two spouses. So, in order to get a fair and equitable division of property, you need information. Fair and equitable has to be based on information. So, a few pointers if you are here because you're going through a divorce, the first thing is information, information, information. Make copies of all of your income tax returns. If y'all have 10 years worth of income tax returns, make copies of all of them. Because a financial professional, a CPA or a financial planner, can look at those tax returns and tell a lot about what it is you own. If you claim income from interest for a savings account, well, then you'll know there's a savings account out there. If you have deductions for business expenses, then you know that there's a business out there to be divided. So collect financial information, income tax returns, paycheck stubs for both you and your spouse, because you can tell a lot from that as to if there is a deduction on there every month for medical insurance, then you know that there's medical insurance out there. If there is a deduction for a payment to some store, then you know that there's that debt out there. So tax returns, paycheck stubs, bank statements. Bank statements are really important because that you can tell a heck of a lot from bank statements. If you see that there is an expenditure every month for XYZ, then you need to find out what XYZ is. Maybe that's a savings account. Maybe it's an investment overseas or in another state. So tax returns, paycheck stubs, and bank statements. Then just about everybody has insurance of some kind. Make copies of all insurance policies. Make copies of all statements from retirement plans. And another big one that some people overlook is every year around your birthday, you get a statement from the Social Security Administration that says how much money you've made. So if one of the spouses say, well, I only make $30,000 a year, I'm self-employed and so forth like that, but the Social Security statement shows that you make $100,000 a month. There's a disparity. A year, yeah. Well, some people make that.
That's true.
Yeah. So the first thing you need to do is make copies of all financial documents that you have. Retirement plans, Social Security, pay stubs, tax returns, and so forth. If there is a family business, then make copies of all of the instruments with regard to the business, such as articles of incorporation, bylaws, and so forth like that. The more information you have, the better off you are. You should also make copies of wills, both your will and your spouse's will. Make copies of credit card statements, because you can tell a lot from credit card statements. If you see that mom charged a weekend at the Lajita Spa down in South Texas, and you say, well, this bill looks like it may be for two people rather than just one person. So get all your credit card statements. If you don't keep those, then get them from the provider. Visa or whoever will send you copies of your statements, but usually only for a couple of years back.
You can also get them online often.
Yeah. Make copies of all instruments with regard to real property, deeds, deeds of trust, promissory notes, mortgage statements, things like that, so you can you have all the information needed about the real estate that's owned. Make copies of medical insurance policies. It'll tell you, usually you can get a statement that says, gives a summary of what's covered by insurance and what's not covered by the medical insurance. Make copies of the, if you have car titles, make copies of those. Make copies of any instrument that shows ownership, such as stock certificates or statements from brokerage firms, things like that, so that you can determine what's out there, what it's worth, or if it's a debt, how much is owed. So make copies of all financial documents. And here's a big one, and it usually comes down to this in quite a few instances. You get everything settled in mediation or in collaborative law, and the big sticking point is in what I call Aunt Minnie's vase. Here's a keepsake that your Aunt Minnie gave you years and years ago, and it's in your spouse's house after you separate. You want Aunt Minnie's vase. Well, here you are a year into the divorce. You've been fighting over exchange of documents and dividing up property, if Aunt Minnie's vase is really that important to you, when you separate, take it with you. It's easier to give something back than it is to try to get it from the other spouse. So take care of things that have a special meaning to you that may not have a big financial worth. So take Aunt Minnie's vase with you. Take all the photographs and make copies. If there's photographs, family photographs that have your spouse in it, make copies of those. Give them to the spouse. They may not want to have copies of pictures with the two of you in it, but they certainly would want family pictures that have them in it. The same thing with the videos. And I grew up in the era of 8mm, so I know it's easier now that if you have family videos to get those reproduced. I know there are places you can go. If you have VHS tapes, you can take those and have them put on a CD and so forth. So take the things that might disappear. Make sure that if you have a lot of jewelry, you take every piece of jewelry with you when you leave. Or if you're still living together but separated and going through a divorce, then take them to your mom's house or Aunt Minnie's house and make sure that you safeguard those things. So the big deal in planning for your divorce is make sure you have the stuff that has meaning to you with you when you do separate, or make sure that that stuff is safeguarded. If you are about to go through a divorce, one of the first things you should do is get off of Facebook. Don't tweet. Those things are dangerous for several reasons. One is you're liable to say something on Facebook or say something in a tweet that you really don't mean. It's something that you may have this niggling feeling about. Oh, well, my husband doesn't use deodorant, or some such thing as that. Well, you don't need to tell the world about that, and you don't need to have that in your husband's mind. Well, she thinks I stink. Well, don't do stuff like that. If you're going to go through a divorce, get off of social media. Don't use it. Your kids can still use it, but don't you use social media. The only thing that social media can do for you in a divorce is to bite you in the rear end. So do away with social media. Fine, after the divorce, you can do that. Another thing is, don't bring your boyfriends or girlfriends around the children unless it's a serious relationship. So if you're dating somebody, agree to meet at a restaurant. Agree to be picked up on weekends that aren't your parenting time weekends. But don't run boyfriends and girlfriends through your children's lives. That's one of the worst things you can do. And if for nothing else, it's for a safety reason. You just met this person, you're starting to date them, you don't know anything about them. They could be thieves. They could be coming to your house and determining what it is they can steal. But the main danger is, it could be a danger to your children. So don't bring boyfriends, girlfriends into your children's lives unless it's a serious relationship. But also don't do that because it's going to make the other parent mad. Well, look at that. I mean, she's already dating. And how do you know that? Because the kids told you. Another thing is, and that segues into that, I can't believe I did that, but don't use your children as spies in the other household. Mm-hmm. Do not ask your children, well, who was over at Mom's house while you were visiting this weekend? You can ask, what did y'all do? But don't make it so that you're using the child as a spy, because the child is going to think you're using them as a spy, even if you don't intend to use them as a spy. So something as innocuous as, what did y'all do this weekend, may not sit well with your child, so just don't do it. If they want to offer information, fine, but they are not the CIA, they're not your personal private investigator. Don't use them as such. It puts them in the middle of an adult situation, and it makes them rat on the other parent. Go.
Thank you. There are ways to talk to your children about what they did at the other parent's house that are much more productive in terms of your relationship with them. And that's questions like, what was the most fun thing you did this weekend? Or did you read any great stories? Did you play with anybody? Those kinds of things that require a conversation, which builds up communication between you and your children, helps you know what's important to them, and does not involve them in spying or reporting. The other danger about asking kids to spy on the other parent, either on purpose or accidentally, is that if a child has a grudge against the other parent, they're going to make up stuff. And don't think they won't. They'll report stuff that isn't true because they think it's going to get them brownie points. So in terms of behavior, first of all, I would also advise don't have a boyfriend or a girlfriend if you're going through any custody issue while the divorce is pending. It's just not a good idea. Whether your children know about it or not, I wouldn't want to have a client have to face a question, so who are you dating? And then the ultimate question of, well, how much of the community income are you spending on that parent or on that paramour, basically? And, you know, you don't want to have to answer questions like that, so just don't do it. That's another reason to go into a mediated, arbitrated, or collaborative settlement, because it's a much faster divorce. And with regard to the children, every study has shown that children thrive when the divorce is as short as possible and there is as little fighting as possible. In terms of assisting your children in their lives after a divorce, if you have very young children, one of the things that I think can be very effective in terms of helping them know, even if they have only every other weekend with the non-custodial parent, is to get 2 identical calendars at the beginning of the school year and pick a color for mom and a color for dad. And then at the beginning of every month, just go through the calendar and put dots on the calendar so that one calendar's at mom's house, one calendar identical is at dad's house. And they get up every morning and they look at that calendar, and according to the dot, they know that's where they're going to sleep that night. And then it gets rid of those kinds of questions, and it's a very visual thing, and if you involve the children in doing that, it's a beneficial thing. You can also say, wow, this is a weekend you're going to go to dad's house, or this is a weekend you're going to go to mom's house. The other thing that I think is very, very important is to help the children remember the other parent. It's dad's birthday next weekend. What kind of a card should we make him? Or, you know, Mother's Day is coming up, let's go out and buy mom a card, or let's make mom a card. And you may not be particularly interested in doing that, but your children are. And they will remember that you have encouraged them to love their other parent. And in Texas, in any event, one of the factors that is to be considered if you ask the court to give the custody order for the children is which parent has encouraged a relationship with the other parent. So to the extent that you acknowledge that this person, even though you can't be married to them, is in fact the parent of your children, the better off the children are, the better off you are, the better off the other parent is. And, you know, I can't think of anything more tragic than after, children are 18 years old, that they look back at their childhood as a broken home as opposed to a restructured family. And if you're lucky, those children will remember both parents at all weddings and graduations and baptisms, and you will have presumably children and grandchildren together. It's very important, even if they're toddlers, to remember that that is in your future. And it's the greatest gift you can ever give your children, is to have them love both parents.
And one judge that we know used to put it in a way that I still use, and that is, you're divorcing, but you're going to be going to the same funerals, weddings, and birthday parties for the rest of your life if you have children together. So you're divorcing as spouses, but you still remain a family. You are still family members because you're going to go to these same functions together. You're certainly going to go to your children's weddings together. When I say together, you're not going to drive in the same car probably. Very few people can do that. But you're going to go to the same important life events as your ex-spouse is going to go to, and your children are going to be there. And how are they going to be able to develop a good relationship when they get married or form a partnership unless they see the important people in their lives, their moms and their dads and their aunts and uncles and grandparents, recognizing that there is still a family here. Although the parents may not be married to each other anymore, they are still a family.
Right. I overheard a conversation between two little girls, and one of them, both of the children came from divorced families, and the one little girl asked the other one, "Who do you live with?" And she said, "I live with my mom and my dad." And the other little girl said, "But wait a minute, they're divorced." And the first little girl said, "So?" That's what we want.
That's the ideal.
Right. So, lastly, we wanted to talk about how it is that you choose a lawyer.
That should be the first thing we talk about, shouldn't it?
No, it should be the last thing. It could also be in the middle. I think it's very important to pay attention to who you hire as a lawyer. If you were going to buy a house and you wanted a lawyer's input, you probably would not go to a criminal lawyer. If you are getting a divorce, even if you think that it will be virtually uncontested or will be settled in the end, you should hire a family law lawyer, someone who has experience. You don't want an out-of-work oil and gas lawyer. They are perfect at oil and gas, but they don't know the system, they don't know the law, and they don't even know what to look for. Like in reviewing a tax return, if they are a, criminal lawyer, they might not know that this on a tax return means that they have this asset, because looking at tax returns is not something they would normally do. Just like if I used to tell people I never practiced criminal law because if I did, somebody that had a parking ticket would probably end up with a life sentence. Mm-hmm. Because I don't know the first thing about criminal law. And so you need to look around and find someone who meets your temperament. You don't want somebody who is very aggressive, whose attitude is, well, we're going to show them. Like I said before, if you're going to end up with 38 to 45% of the time, why would you hire a lawyer, pay them a lot of money for 1 day extra a month or 1 day extra a year or whatever? There's no reason to fight, and you need to find a lawyer who meets your temperament, who will listen to you, sometimes the lawyers may not think you're a good fit for them either, and hopefully they will say so. You need to find out, is this a lawyer who will communicate directly with you, or that you don't need to be notified of every single step along the way? And one of my mentors used to say to me, "Jolene, don't make the mistake of thinking that you get to make the decisions in this case. You tell them what the options are, you tell them what the law is, they get to make the hard choices." And I have never forgotten that, and I never took a client who wanted me to basically tell them what to do. That's not my job. My job is to inform them of the law and represent them when they've made the decision to get a divorce.
It's a personal relationship. It should be somebody that you understand and that understands you and that you trust. Don't hire a lawyer just because your Aunt Minnie used this same lawyer and it was really cheap divorce. Find somebody that you get along with, that you can have when I say personal relationship, it's against the law, it's against the criminal statute, in fact, for lawyers to have personal relationships with their clients or to have business relationship with their clients. So you don't want somebody like that. I'm not talking about that kind of relationship. I'm talking about somebody that you can what's that word? Communicate with.
Right.
And I forgot something when I was talking about documents to come up with. I have, we prepared a sample inventory and appraisement. When you first start your divorce, get a form like this and write down all of your assets, all of your liabilities, and the dates and times that those things came into existence. Sorry, back to.
That's all right. One of the benefits of doing that is, first of all, you will educate yourself. And number two, it helps keep down attorney's fees because you've done all of the work that ultimately will need to be done. And you might as well do it yourself as have to pay the legal assistant to do it or the secretary to do it. And it's just a good piece of information to have and always have. So, you know, whether you ultimately end up getting a divorce or not, you will know what information you need to know. Part of the benefit of having this information is it puts you in a position of power, and I don't mean power like in a war situation, but power in terms of control of your own life and knowing those things, having that information.
That segues right into, anybody have any questions? And if we've done our job fairly well, there shouldn't be very many questions. But if you have a question about your particular situation or in general, let us know. We'll also be here for a while after we adjourn, and if you want to ask a one-on-one question. Anybody?
Okay.
All right.
Thank you very much. I appreciate your time. I know Bruce does too. We appreciate the opportunity to come and talk to you about something that's very important to both of us.
All right. Thank you.
Thank you.